Now, High Court judges Eric Ogola, Anthony Mrima, and Freda Mugambi have declined to strike out an affidavit by current hospital director Dan Gachagua linking President William Ruto to Rigathi Gachagua's impeachment. They have instead directed Parliament and the Attorney General to file responses whether they wish to question him. The affidavit has been the main bone of contention, with the petitioners and respondents' advocates disagreeing on its admissibility in court, as Gachagua's counsel told the courts he was bedridden on the day he was to be cross-examined, and thus he was condemned unheard. Alan Ochanda attended the proceedings and prepared the following report.
High Court judges Eric Ogola, Freda Mugambi, and Anthony Mrima declined to strike out an affidavit filed by current hospital director Dan Gachagua linking President William Ruto to his former deputy Rigathi Gachagua's impeachment. They have instead ordered that Parliament and the Attorney General should file responses and indicate if they wish to question him so that he can appear in person on May 13th in what is seen as a major stride for Rigathi Gachagua's legal battle over his impeachment. The Defense Counsel had contested its admissibility, arguing it came late in the day and bore defects.
This affidavit ought to be struck out because it changes the parameters of our responses.
We have considered submissions on the admissibility of the affidavit sworn on 28th of April 2026 by Dr. Daniel Kibuka Gikonyo. Despite having noted that the petitioners did not address the apparent delay in filing the affidavit, we nevertheless deem the said affidavit duly filed and properly on record in the wider interest of justice. We therefore make the following further orders.
Gachagua's legal team has premised their submissions on the affidavit, arguing that the ousted DP was bedridden on the day he was to be cross-examined. To this end, they say he was condemned unheard and thus want the courts to quash the impeachment as it stands on his political journey permanently.
That the deputy president was denied the available legal tools under Article 50 of a fair hearing. The Senate sat as a tribunal. The Parliament, National Assembly equally sat as a tribunal. When it is sitting as a tribunal, it cannot be exempted, Your Lordship, from the dictates of a fair hearing, equal protection of the law, and all procedures that invites it to uphold the Constitution. This could not have been said to have amounted to an impeachment.
We cannot have a counter-majoritarian situation where the elected representatives make a decision which is then reviewed for policy purposes by a non-elected branch.
The case was heard and determined in Senate plenary, and according to the petitioners, a special committee will have been more ideal.
That they indeed substituted the place of the special committee with the Senate committee, or the Senate sitting together as a committee. Then it therefore means that a very crucial step that is required under law was missed by the Senate at the point of deciding that the former Deputy President, His Excellency Rigathi Gachagua, should be impeached from office.
The multiple petitions in the ongoing Rigathi Gachagua impeachment case are not seeking to reinstate him back to office, but to secure his political lifeline. All eyes are now on the three-judge bench as to whether they will agree with the petitions or not. Alan Ochanda, KTN at the Milimani Law Courts.